My name is Maury Griffith. I'm going to be walking you through your last will and testament. So I want you to pull out of the packet of documents you received the document that is entitled Last Will and Testament of, and your name should appear there as well at the top. Before we get into this document, I want to just kind of briefly explain something about your document that might be a little confusing. I call this type of will a contingent trust will. That is different from a living trust that many people have as a part of their estate plans. A living trust is a trust that you create, and during your lifetime you actually put your property in the trust. So you title all of your bank accounts in the trust, you might be titling real estate into your trust, you do all of that during your lifetime. That is to be contrasted with the type of plan that you have here. This type of document, you have a will and you have a contingent trust built into your will. The contingency is your death. So you're not putting anything into this trust during your lifetime. Instead, at the instant of your death, or if you're a married couple, at the second death, that's when this trust is created. That's when the executor is directed to put things into this trust, and typically it's for the benefit of your children. So I just want you to know the difference between the two, because you might be seeing a lot of information out there in the mail or in magazines or from wherever about people talking about they have a trust. Yours is a little different from that. So this type of plan is very typical for younger couples who have children, or for couples who don't have a massive estate and they want to give all their property to their children at the second death, but maybe they don't want them to get it right away. So let's start by walking through your document. As I said before, it should be titled Last Will and Testament of, and then your name should appear. Please make sure your name is spelled correctly. As you walk through this document, you're going to see an opening paragraph there, and it says I, and your name should appear, and your address should appear. And it says that you're making this your will and you're revoking all of your prior wills and codicils. A codicil is just a change to your will. So to the extent you've done one of these before, a will before, you're revoking that. This will now takes precedence over the old ones. Again, make sure your name and address are correct. Paragraph 1 is titled Interment. This is your directions to us as to what you thought about burial and or cremation. So if you're going to be buried, please make sure that we have your cemetery listed there correct and the city and state correct. Depending on what you've told us about whether you have a lot or a monument, we would have addressed that language here. So typically people don't have lots and monuments, and we say that if it's necessary to buy a lot to bury you in and to buy a monument, you're giving the executor the authority to do that and to pay the expenses related to that, as well as your expenses for funeral and burial. If you're going to be cremated, that language should be here as well, and it will talk about how to treat your cremation and what to do with your ashes after you are cremated. So make sure that we have that correct in this paragraph. Article 2 is what we call the personal property article. This article deals directly with some types of personal property that you may have. And it kind of outlines what we're talking about right there in that first paragraph. It says, I give all of my jewelry, pictures, books, household furniture and appliances, clothing, automobiles, and articles of household or personal use or ornament of all kinds to whomever you're giving it to. Typically, if this is a husband and wife type of plan, it's going to have your spouse's name there, and please make sure whomever you've selected to get this stuff, they're listed there. You may have directed that certain items be given to a certain person. That will also be listed in this article. And then let's assume that you have a typical husband and wife plan where you're giving it to your spouse first. We'll say, or if that person is deceased, then to such of my children as are living at my death to be divided as they decide. Except that if a child of mine is deceased, leaving one or more children, so a grandchild of yours, I give the deceased child's share to their descendants. Now, one of the things I want to point out here is that if you have this personal property is going to be going to your children, they are going to get together and decide who gets what. It's not that you're saying, everyone gets an equal share of everything. They're going to have to get together, decide who gets what. If one of your children is deceased, that deceased child's children are going to get their share. Now, the decision as to what those grandchildren are going to get is going to be left to your children. And the reason is we don't want grandchildren who are more remote, don't have quite the sentimental attachment that your kids might have, because your kids might have grown up with some of this personal property that we're talking about. We want them to be able to decide how much your grandchildren are getting and what types of property you're getting. That, I think, eliminates a lot of fighting. It allows your children to make the call based on their sentimental and emotional attachment to your property. This paragraph continues on and describes that you may leave a memorandum, which is not a part of your will, listing some items you wish to leave to certain people. Illinois law authorizes you to have just a little sheet of paper that you can include with your will, and we can provide that for you if you desire, to list certain items that you want to go to certain people. You may not want to include that in your will because you don't, if you change your mind later, you don't want to have to come back to our office to amend it. This is a good way to maybe some dishes or a ring or something of that nature that you may think you might want to change your mind later. The memorandum is a good way to make sure that property gets to those people. So if you want to do that, let us know. We'll provide you with that memorandum. Typically what we have here at the end of this first paragraph is the names of your children as are living today. So if we have that there for you, make sure we spell their names correctly. The next paragraph, if you have minor children, this will be there, and we say that if a child of yours has not attained legal age at your death, the executor may deliver his or her share of that personal property to your children's guardian. So if all of your children are adults, we won't have that paragraph there. If you have minor children, we will have that paragraph there. The following paragraph should say, this article shall not include the following types of property. And we're talking about money, securities for money, choses in action. And a chose in action is really rights under a lawsuit. So if as a result of your death, a wrongful death lawsuit ensues, the rights under the lawsuit of your executor, that's what a chose in action is. Stocks, bonds, accounts, evidences of debtor titles or mortgages, insurance policies, those types of things are not included in this personal property article. So those types of things are not going to go directly to your children. Instead, all of these types of assets are going to pass with the rest and residue of your estate. And that leads us right into the next paragraph, which is probably entitled in your document Contingent Trust Provisions. Whatever it's titled, it starts out and says, all the rest, residue, and remainder of my property. So anything we haven't already dealt with. So all of those personal property items we've already dealt with. If you've made specific gifts in your will, we've already dealt with those. We're talking about everything else. All of that stuff goes to the person you've named, and that person's name should be there in your document. Typically in a husband and wife plan, that's your spouse. But we say if that person doesn't survive, and if you've got a husband and wife plan, it says if my spouse does not survive, then I give the residue of my estate to, and you're going to name a person. That person's name should be listed there. And that's the person that's going to be the trustee of your children's trust. So you're giving all the property to that person as trustee to be held and administered according to the following provisions. Now this is where your document is going to differ depending on what you told us in your meeting with us. You have a couple of choices, and again, think about where we are here. By the time we're setting up this contingent trust for your children, you're dead and your spouse is dead. So the primary people involved here that own the property are deceased, and now you're passing it down to the next generation, the children. But you're telling us that you don't necessarily want your children to get it right away. Maybe they're underage, or maybe for whatever other reason you decide they're not quite ready to handle it. So this is where you're going to decide how they get their property. So your trustee is going to hold it, and you're giving directions to them as to what to do. You have two kind of basic options that we would have talked about in your meeting. And your option will be shown here. I'll go through both of them though, just in case yours is different than what someone else has. The first option is what I call the immediate shares option. In that option, you're telling your trustee, take all of our property and immediately divide it into separate trusts for our children. So let's say you have two children. You're saying, trustee, take all of our assets in a pot. Now take half of those assets and put them in one trust for one child. Take the other half, put it in a trust for the other child. Those trusts are to benefit those particular children. And then you're going to pick an age that your children start to get rights in that trust, so distributions from that trust. Let's say that you want to make sure your child gets through college without having used up all of their trust. So let's say you pick age 21. Maybe that's the typical age people are graduating. I don't know. Depends on how quickly your child can get through. So let's say age 21. So before they reach age 21, you're directing your trustee to pay as much of the income and principal out of that child's trust for that particular child's benefit. It might be health care, they may get sick. Education, you can get them through college. support, maintenance, whatever needs they may have, trustee, you're authorizing them to pay money out of their trust for those purposes. When the child reaches a certain age, which you will have told us and it will be shown in this document, again, let's say it's 21. At that age, they're going to be entitled to receive income. So, trustee, at that point, you're directed to start paying income out. So you pay any expenses that might be involved in administering the trust. Then you pay income out to that beneficiary. And then you have also told us the age or ages you want them to start receiving principal. Let's say you decided maybe at age 21 they're not quite ready to receive the whole lump sum out of their trust. Maybe you want to break it up into 2 ages or 3 ages. Well, we will have listed those ages for you here. And it's at those ages that your beneficiary, your child, has the right to direct the trustee to distribute either all of their trust, a half, a third, whatever it is that you've decided. Those ages, they get their share. Now, one of the key things that you should know about restricting rights in a child's trust is until they hit those magical ages that you've designated, no creditor has the right to take their share of the trust from them. So let's say that you say at age 25 they have the right to withdraw their whole trust. You've made sure they've gotten through college, they've paid for health, education, those kinds of things, and at age 24 they're out of college and now they're in an accident and they're sued for however much ungodly money they're sued for. They can take everything that child has, but they don't have rights to take that trust because the child has not hit the age of 25 yet. So you do get some creditor protection by restricting rights to a certain age. You're also saying in this type of plan that if a child dies, his or her share goes down to his or her descendants. And you've also picked an age, which will be shown in here, at which they get their property. So that's kind of the basics of one type of plan. I call that the immediate shares plan. In other words, trustee, when we die, take all our assets, put it into shares immediately for those trusts, and the kids benefit out of their trust only. The other type of plan is what's called a single fund trust. So let's back up. Both you and your spouse are deceased, or if it's a single parent, you're now deceased. The trustee now has all these assets. You're saying, trustee, hold all of our assets into one pot. And I want you to hold those until the youngest of our children reaches this magical age, whatever age you select. Until that time, until the youngest reaches that age, trustee, you're directed to pay out for all of our children, in your discretion, whomever needs it, for their health, education, maintenance, support, all of the things that you would provide or may provide as a parent. And then when the youngest child reaches that age, at that point, you're breaking it out into separate trusts for your children. And then you can define what the rights are for those children. So you can, again, go back, and it kind of, at this point, relates back to the immediate shares. We're at the age where the youngest child hits, let's say you pick 21 again. At 21, you're saying, trustee, now divide the trust out into 2 trusts. And then you can say when your beneficiaries get rights to income out of that trust and when they get rights to principal out of that trust. Now, if a child dies, again, you're saying his or her share goes down to his or her descendants, and the trustee has the right to pay for any funeral and burial expenses of my child. So that's kind of the basic way, basic 2 ways you can handle this type of trust. You either create immediate shares at the second death, or you create a big pot to hold it in until the youngest child reaches a particular age, and then you divide it into separate shares. So whichever plan you've picked should be listed here. Now, after we get through that, you're going to come to a paragraph that says, upon the death of a child of mine, after a trust is created for him or her, and prior to complete withdrawal of that trust. So there may be a situation where you've created shares for your children, and prior to the time they have the right to take their money out, they pass away. Well, you're saying then in your document that the trustee has the right to pay for your child's the expenses of his or her last illness and burial, so they can pay for their funeral, they can pay any taxes that may be associated with your child's estate, any attorney's fees or accountant's fees that may be involved, or any other general expenses that may be involved as a result of your child's death. You're giving the trustee the authority, the discretion to make those payments. And as you follow on in the document, it says, after making those payments, the trustee shall distribute the remainder of the child's trust to, or as he or she may appoint by his or her will. provided that the child attained the age that you selected. So whatever the oldest age is that you said, they have to have had to reach that age so that they can make a will to appoint their property. And their will has to make specific reference to your trust. So we really want your child to have thought this through. We want to make sure that they've hit that magical age so that they have full rights to it, and if they have the right to direct where their share is going to go. Not necessarily to their descendants, as you might have said, but they have the right to decide where their property is going to go, provided again that they've hit that magical age, and they've made a will that makes specific reference to your document. Now, if a child, continue on with your document, the next paragraph, if a child shall either not have exercised this power, so they didn't write a will referring to your trust, or they didn't reach the age that they were supposed to reach, then the trustee is directed to divide the remainder of that child's trust per stirpes into separate shares for the child's living descendants. Now, per stirpes is kind of a Latin word for bloodline. So you're going to be looking for your child's children, and if there's no children present, then they're going to be looking for your other children that are living. Now, it continues on and says, if a child dies without descendants, then you're going to divide the shares, again, for your then living descendants. And again, it's per stirpe. So, child dies, first look for his or her children. If there are none, go back up, look for any other children I might have living, and then give it to them. If one of them is deceased, look down their bloodline to see if there's any. So that's the kind of distribution scheme you have here. In the next paragraph, we're saying, each trust which is created for a descendant of a deceased child shall vest immediately in that descendant, but they don't have the rights to it until they reach a certain age. So you're saying if a child dies and he has children, so your grandchildren are getting your child's share, you have picked an age which they get it. Typically that's 21, but you tell us what age you want your grandchildren to have rights to their shares. We don't want these trusts to go on forever, so pick a reasonable age so that at some point this trust can end and it can be distributed out. In the following paragraph, this is what I call the disaster clause. I call it that because, and I'll read through a little bit of this and you'll see why. It says, if my spouse does not survive me, and if upon my death or at any time thereafter, but prior to complete distribution from the trust. So, at the time of my death, my spouse is gone, and at that time, there's no living descendant of mine, so I have no children, I have no grandchildren. There's money left in this trust. What happens? So everyone in your immediate family is deceased. What do you want to have happen to your property? So as you follow along here, we will have listed out what you've said if you've elected to have a disaster clause. If you're a husband and wife and you have minor children, I strongly urge you to have this type of a clause because, in the event of a house fire, tornado, something of that nature, you're on a vacation, the plane goes down, there may be a situation where all of the intended beneficiaries that you have are no longer there to take their share. In that case, I want you to tell us where your property goes, and what you've told us will be listed here. In the next paragraph, we're saying for all purposes under this will, legal adoption is to be either treated as bloodline or it's not to be treated as bloodline. So in other words, you need to tell us how you feel with regard to adoption. Either adoption is okay, treat them as if they're a child or a grandchild of mine, if there's an adoption in that line, or adoption is not okay. You do not want adopted children to be treated as if they're part of your bloodline. You do not want adopted children to be treated, or grandchildren to be treated as a part of your bloodline. So you just let us know and we will put that in for you here. In the next paragraph, we're saying any income or discretionary principal payment due to any beneficiary which the trustee determines the beneficiary is unable to properly administer shall be made in any one or more of the following ways. And we give a list of four ways the trustee can administer the beneficiary's payment in this type of a situation. They can, if they feel it's appropriate, deliver it to the beneficiary directly. They can deliver it to their legally appointed guardian. They can deliver it to some relative or friend if they think that's appropriate for that beneficiary's health, education, support, or maintenance. And finally, the most common, by the trustee for the beneficiary's health, education, support, or maintenance. So the trustee can decide, I don't want to distribute it at all directly to anybody, but I will pay for health, education, support, and maintenance. So we're giving the trustee some flexibility if one of your beneficiaries, even though they may be entitled to their distribution, isn't quite ready to handle it. Now, the next paragraph is important because it says the interest of the beneficiaries in the principal and income shall not be subject to the claims of any creditor, any spouse for alimony, support, or others, or to legal process. So what we're trying to do here is protect your beneficiary's share of the trust from creditors that he or she may have. I will tell you that this language really serves as a deterrent. It is not necessarily a guarantee that creditors can't attach to it. However, if you have restricted your beneficiary's right to get their portion, let's say you say they can only get it at age 25, if they haven't hit that age yet, then no creditor can attach to their share of the trust. The next article talks about trustee powers and duties, so please look for that article in your document. This is a very short section, but it has a very broad impact. It says the powers and discretions granted to trustees under the Illinois Trust and Trustees Act, in effect on the date of execution of this instrument, shall apply to each trust created. The Illinois legislature has created a very broad statute giving trustees very broad powers for managing all types of assets that you may have in this trust. Real estate, stocks, bonds, CDs, bank accounts, anything you can imagine is pretty much covered. And it lays out specific rules about how they're supposed to treat that property. They're supposed to invest it prudently and do things for the benefit of the beneficiaries. We didn't take the time to list out each of those duties because we wanted this document to be relatively concise. So just know that that statute is very broad and it gives your trustees the power to do pretty much anything they need to do. The next article talks about trustee employment provisions. I want to walk through some of these for you. The first paragraph says any trustee may resign by giving written notice. We want to have this power in here because it may come to the point where your trustee, for whatever reason, can't continue to operate as trustee or doesn't want to continue to operate. You want to have them give the right to resign. They're not servants or slaves. They should have the right to resign, and we've given them the power to do that. In the next paragraph, we're saying, should your trustee resign or cease to act for any reason or refuse to act, then you're naming a backup, and that's where it should be named. If we have one or more backups that you wanted us to put in here, please make sure we've spelled their names correctly. It may also come to the point where your primary trustee doesn't serve for whatever reason, and your backups can't serve for whatever reason, and that's what the next paragraph is designed to deal with. It says, in the event of a vacancy in the office of a trustee, a successor may be appointed trustee by an instrument delivered and signed by my children if they're adults, otherwise by their guardian. So you're giving the rights to your children to appoint their next in line trustee if there's a vacancy in the office. Again, they have to be adults to do that, and if they're not, then their guardian has the right to do that. If there's nobody there to make that decision, we're saying the successor trustee must be a bank or corporation. And again, we want to end with that because if there's no one else as an individual that wants to take this job, we want to be able to assign a bank or corporation that deals with trust to be able to take over and run this trust. Now, with respect to any notices that are being sent out, so if the trustee resigns and he's giving a notice of resignation, or if an accounting is being delivered to beneficiaries regarding the receipts and disbursements in the trust, it says in the next paragraph that the guardian of your children or their parents may receive this notice, and that guardian or parent may sign any instrument on behalf of your beneficiaries if they're underage. The next paragraph talks about, well, it's actually a legal requirement that gets very complicated, but it goes back to my point I made earlier that the law does not want this trust to last forever. So basically it says that no trust created shall continue for more than 21 years after the death of the last to die of myself and the beneficiaries in being or living at my death. So take all the people that you have alive, your kids, your grandchildren, 21 years after the last to die of all of them, this trust by law is going to terminate and distribute to whoever the beneficiaries are at that time. I think you and I know that this trust isn't going to go on that long, but we have to have an ending date, and that's it. The next paragraph says that when your beneficiaries reach 18, the trustee has to start giving accountings to them. At age 18, your beneficiary may or may not want to look at those things, but at least they have them coming. Someone is accounting to them, making sure that they're telling them the receipts and disbursements. Your beneficiary has the right to look at those, to see what's going on, what investments are being invested in. how much money is being generated and what's going on with that money. So at age 18, your beneficiaries are required to start getting accountings from your trustee. The next paragraph deals directly with life insurance policies. So at your death, there may be some life insurance benefits that are payable to beneficiaries, to your estate, to your trust. We're saying in the following paragraphs that the trustee shall take such action as they deem necessary to best collect those insurance policy proceeds. But we're saying, trustee, you don't have to enter into or maintaining any lawsuit to enforce the payment. Now, typically, we've run into insurance companies dragging their feet on paying. We've never had to actually sue an insurance company for failure to pay on a policy, but we're saying, trustee, you know, if it's a very small policy and it would cost a ton of money to litigate this, you're authorized to not enter into that sort of lawsuit and deplete our other assets for our children in order to get a relatively modest gain. In the next paragraph, we're saying the insurance company need not take notice of the provisions of the will or see to the application of the proceeds. In other words, we don't want every insurance company out there to be looking at your will and making sure the trustee is taking the money and doing what they're supposed to do. We want them to be able to rely on the trustee. The trustee fills out the form, submits them, takes the money, and then the trustee is directed to do what you've told them to do under here. We don't want outside insurance agencies to try to be policemen about what your trustee is doing. The next article is entitled Guardian for Minor article. This is, as it kind of indicates in the title, where you've appointed a guardian to look over your children while they're underage. So please make sure that you have named somebody here, as this I'm sure is one of the primary features of why you're doing an estate plan at this point. Make sure we've named the people, we've got their addresses spelled out, and that all that information is correct. The next article is entitled Survival of Beneficiary. This article says, no person who is a beneficiary under this will shall be deemed to have survived me unless he or she is living on the 30th day after the date of my death. What this provision is designed to do is let's say that you are in a common car accident and it's, you know, parents and children. We don't want multiple estates to be created. So if that's the situation, you may have part of your trust or your estate being payable to a child. If we didn't have this provision in, and you all died at the same time, we'd have to pay that money out to the children's estates, and then we'd have to open up probate estates for them in order to deal with that property.